Vanakkam Sondangale. So 3 days ago, USCIS dropped a memo on adjustment of status. And it has created a massive buzz among the immigration community. By now, most of you probably would have known a little bit about what it is. However, instead of clarifying things, this memo has raised multiple questions and we are seeing a lot of misrepresentation circling on the internet, causing confusion. So instead of guessing or relying on some random forwards, today I have partnered with Manifest Law. I'm joined by Gabriela Urizar, an immigration attorney at Manifest Law with almost a decade of experience handling business immigration, work visas, and talent visas. Thank you so much for joining us on a Memorial Day weekend.
Sure. Thank you so much for having me, Rajesh. I think you did a pretty good job.
Okay, my first question is, Gabriela, in plain terms, what is this memo and what it does and what it does not mean?
Right. So I just want to provide a brief disclaimer that this is for educational purposes only. It's not legal advice. And this is my interpretation as an immigration attorney. Different attorneys have different interpretations, like you said. A lot of confusion, a lot of issues. I think the biggest misunderstanding here is that people believe this memo is changing the law, but it's not changing the law, right? The discretion on officers to adjudicate adjustment of status application has always been there. The memo is just a very strong reminder to officers that they have the discretion to approve or deny adjustment of status applications. And also something that's interesting though is that they add a standard that's actually not included in the law. They're telling officers that unless somebody shows extraordinary circumstances, then they have to go and get a green card via consular processing, which a lot of people panic, right? Because that means interruption of jobs, family separations. Also, we have the 75 country ban list that people from those countries cannot get a green card via consular. So what options do they really have, right? The memo doesn't say that people are no longer allowed to apply for adjustment of status inside the United States. It just increases the emphasis on the discretionary part, right? Also, something that's important is that we're hearing communications from different government officials, and we can talk about it deeper later on about the claim on H-1B holders, right? Having the ability to still continue pursuing their adjustment of status applications. But the memo is just a reminder for officers that they have discretion to use a heightened discretion to allow people to stay in the US who can demonstrate that they have ties in the US, speak English, have a job, are paying taxes, haven't violated the law, and also a higher scrutiny on people that enter on either parole, a student visa, or a work visa that doesn't have dual intent. In this moment, it is my professional opinion that people who are in the best position are H-1B holders and L-1 holders because that allows for dual intent.
Okay, and my next question is who's at high risk under this memo and who can relatively breathe easy?
So people who are at the highest risk, in my opinion, are people who enter on temporary visas, like, for example, the tourist visa or a parole, and then they marry a U.S. citizen right after they enter. So again, officers are going to look into the intent of people at the time of applying for the non-immigrant visa and also entering the country, because when you get one of these visas, you make the attestation that you don't want to be here permanently, right? Also people who have prior status violations, who maybe overstay their visas, people who work without a work permit, people who have inconsistent statements, possible immigrant intent issues, fraud or misrepresentation. People, like I said before, who are in the best position are people who have come to the US or transferred to a work visa that has dual intent, like the H-1B or the L-1. They do allow by law for people to pursue permanent residency, so you don't have an issue of intent or misrepresentation, because once you have the visa, you're allowed to have dual intent.
Okay, and as you said, this is not a policy change. The rule is already there and they're just asking their officers to interpret differently. So being said that, so does this memo apply to people who already filed their I-485 or only to the new filing going forward? Does that memo says anything about the past cases?
Short answer, nobody really knows. Long answer, memos are rarely retroactive. Like, look back at the memo for the $100,000 fee for H-1Bs. Officers came out later on and they specified that it didn't apply to visas that were filed at a certain time. The memo doesn't say anything. It doesn't say anything about when it applies, if it's forward, backwards. Again, memos rarely go back and are retroactive. But remember, this memo is different because the rule of an officer having discretion was already there,
Yeah,
even for petitions that are pending.
yeah, that was my confusion because, as you said, I understand that the rule was already there, so it's not a policy change. So, if it is not a policy change, wouldn't it should apply for a pending cases? But that's a question. Anybody could okay, it seems like it could apply.
Right. But I don't want people to panic, right?
Yes.
Because even if it applies, people still have the ability to provide information that can help them show that they're here. Like, and this is an example for Indian nationals who, as you know, sometimes have to wait 10 years, 12 years to get their green card. Think about it in terms of implications. They have already established a life here. They pay taxes, they have degrees, they have really complex jobs. So it helps them, right? In my opinion, because they're able to prove that they have a strong basis for staying here, like they have their children in school. Now, something that's very interesting is that attorneys have already started sharing on LinkedIn that they're getting RFEs for pending adjustment of status cases. And they've shared a screenshot of the section where the RFE is asking for proof that they deserve adjustment of status. And again, it's not as crazy as people thought, right? Like, oh, show that, you have ties to the US, show that you're working here, show that you pay taxes, like things that people should have done already.
Yeah.
So again, really important not to panic.
Yeah, I mean, I saw that, the screenshot, and basically whoever is following the law, they don't need to panic. So, I mean,
So I think people panic. I think people panic because the standard of extraordinary circumstance in immigration world, that's usually used in defense or deportation removals, which is very high, but it doesn't seem like it's going to apply here.
and they don't even define what is extraordinary circumstances, right?
No, they don't say they don't say anything about what they think is a circumstance like that, right? Like what they do, and they give a little bit of information on the memo is for people to show that, they have family ties, they have paid taxes, they have been here legally, they have jobs, they have degrees, they have, work in like maybe volunteer or go to church, or to really show the roots, right? Like they have a life here in the US.
Okay. So my next question is, what does the profile of a most vulnerable H-1B or any employment-based green card applicant look like? So what is in their history that puts them at maybe a small risk?
So for employment-based applications or applicants like H-1B holders, I think that the highest risk cases are not necessarily people who simply change status, because sometimes there is this fear that, oh my God, I enter with an F1 and then I change status to H-1B. Again, H-1B allows for dual intent. So the bigger concern here are inconsistencies in their immigration history. For example, prior periods of unlawful presence, unauthorized employment, inconsistencies between prior visa applications and current filings, possible fraud or misrepresentation concerns, status violations, or evidence suggestion that the person may have misrepresented their intent at the time of the entry. And this is something that I want to highlight because, again, people are allowed to change their intent, right? So let's say a student came on an F1 and then they transfer on an H-1B and now they're pursuing permanent residency. If at the time that this student requested the F1 and they enter the US, their intention was to go back to their country, that's totally fine. That's what matters, right?
Okay.
Again, later on, they're allowed to change their intent. Maybe they loved it here, right? Maybe they love the food and they want to stay and live in the US. They're allowed to change intent.
Okay, that was really good information because I didn't know. I thought like the original intent should stay. So intent, it can change. Yeah, thank you. So say for example, for someone, okay, if a USCIS denies an I-485 and pushes someone to a consular processing, what are the real risks at the consulate interview that simply does not exist in the adjustment of status process?
So this is a very important question because consular processing carries risks that are very different from adjustment of status. So when someone adjusts status inside the United States, they're allowed to remain physically here, right? So their jobs, family, the flexibility. When you go through consular processing, you have less flexibility. Like consular officers have extremely broad discretion. An officer can deny the application without giving you a reason. USCIS, they have to give you a reason, and usually they give you a second chance, right? Like they give you an RFE or they give you a NOID, like they give you the chance to clarify. a consular officer is not going to give you a chance to clarify. If they don't believe that you qualify, they deny you, and you don't even have a mechanism in place to be able to appeal that, right? So, and also denials are not subject to judicial review, like here in the US. Also, if a consulate determines that there was fraud, misrepresentation, unlawful presence, or anything like that, you could become stuck abroad for months or even years, right? Like until you maybe apply for a waiver or a pardon. So it's very complicated. And then on top of that, you add the list of the 75 countries that are not allowed to get a green card abroad. So 75 countries is a lot of countries.
Yes.
Which leaves people outside with absolutely no recourse.
Okay. Thank you. So since USCIS never defined extraordinary circumstances, what specific factor in a client's file give you a confidence that their I-485 can survive this scrutiny?
So for me, the strongest cases are the ones that where the applicant presents a very clear picture of stability, credibility, a long-term contribution into the United States. So for example, a strong lawful immigration history, again, not a change, not something different for someone that's applying to an EB1, EB2, EB3 application. Work visas and work immigration cases have always been very strict. So if you qualify before, you likely qualify now, right? Maintenance of status, stable employment, tax compliance, strong employer support, family ties in the US, community involvement, clean criminal history, and also something important that I see officers talking about is proficiency in English, which is not a requirement to get a green card. That usually comes at the stage of getting a citizenship. So I'm interested to see how they're going to measure that. But basically, right, like the overall is basically the same requirements that people had when they were applying for a green card based on employment.
Okay, that makes sense. So I've heard like some news that like the DHS told a news outlet that H-1B holders may be able to continue their current path. But that statement is nowhere on USCIS website or in writing, or it's like, as an immigration attorney, how much weight does a verbal spokesperson comment carry versus a signed policy memo?
So even the policy memo is just guidance for the officers. Like that's not the law. It's not changing the law, right? And then you go a step further and you look into verbal announcements. You can take them with a grade of salt, but to me, they're a good indication of what's to come, which is, again, it's the same thing that happened with the $100,000 fee for the H-1B. Like we saw officers or officials like give like brief statements, and then later on, we saw that information being clarified in either the USCIS website or the memo. So I think it's positive. It is a good indication for people who are on work visas. The fact that the government is talking about possibly giving them the ability to continue applying for adjustment of status without any issues if they're contributing to the US, if they have a career, if they're working. So it is a good indication. And of course, as attorneys, we always pay attention to what the government is saying, but also to keep in mind that it's not clear law, right? Like we have to wait and see what the government actually publishes or puts on another memo.
Okay, that makes sense. Thank you. So any other question that you think I could have asked you on this subject?
So I know people are asking me too if this applies to the removal of the 2-year conditional green cards, and it doesn't apply. The memo doesn't talk about people removing conditions on their green cards. The memo also doesn't touch on change of status from one visa to the other. It specifically addresses officers' discretion for adjustment of status.
Yeah, I mean, initially there was a confusion between the change of status and adjustment of status, and some people were like thinking like it's change of status has been affected, but it's not. So it's these two are two different things. So that's all the question I have, Gabriela. Anything else you want to share here, or?
So just a little bit of guidance for your audience, for people not to make any rash decisions. Like I am hearing people saying, oh my gosh, so should I leave tomorrow to increase my chances to get a visa through the consular processing? not to make rash decisions, to speak to an immigration attorney, even if you don't hire them. Just get a consult. Tell them your background, your information, and then once you have all the information and all the cards on the table, then make a decision. But don't make rash decisions.
Okay, that makes sense. Thank you. Thank you so much, Gabriela.
You're very welcome. Thank you for having me.
Thank you. Bye-bye.